executrix of his estate. Can you think of any reason why you would be disqualified from taking on that job?
No, sir.
Judge, I don't have any other questions of Ms. Kirsten.
Thank you, Ms. Kirsten. On behalf of myself and my court administrator and the county clerk's office, and personally, I knew your father not well, but we extend our heartfelt condolences. You know, this is such an antiseptic process, the probate proceedings and the court proceeding, but it's easy for us to lose sight that we're dealing with real people and real emotions and true loss. And so please accept our condolences and best of luck to you and your family in the future. The court has heard all the evidence. It finds everything, pleadings are in order. The court will admit the last will and testament of Travis E. Tyndall is presented this morning to the court to probate, and will appoint Ms. Kirsten as the executor of the will. And I'm sure, Mr. Warner, I have an order in here.
No, sir. Unless Mike Chris got it over to you, I have been pretty much. My Chris at the office has been coordinating this with your Chris, and evidently Holly's supposed to go over there with the proof of death and the oath, and I presume the oath will be ministered there, and she'll take the order. If I presume that's all. I mean, with this situation we're in, I hope that's okay with you.
Yes, sir. No, that's absolutely fine. Upon the completion of the proof of death and the other facts, and which isn't a prerequisite to admitting the will to order, but definitely upon the taking of the oath of office, and when I get the draft order, Mr. Warner, I'm sure it'll be in due form. I'll go ahead and sign it. So as soon as you get the Ms. Kirsten, or the Chris's, as soon as whoever needs to get all the documents in, we'll get it all taken care of, no problem. And then we'll get letters issued for you, Mr. Warner. Do you know how many you're going to need initially?
Probably about 10.
Okay. Miss Olive, it may be today, it may not be today, it may be tomorrow, but whenever, it shouldn't be hard for us to get those turned around immediately. So even if, Chris and Chris can talk, and if, we can get everything prepared, so there's not a lot of downtime.
Okay.
Judge, I appreciate it very much, Judge.
Yes, sir. Y'all have a wonderful day, and y'all are excused. We're done.
Thank you. Thank you, Judge.
So
Take
much.
care.
Yes, yes, sir. Thank you. Hello, this is Trace. Hi, Mr. George. Can you hear me?
Yes, sir.
Um, I'm not sure. How are you this morning, sir?
I'm hanging in there.
Good. It's good to see you. You feeling all right?
Yeah, I kind of, I always have my at least one yearly little weird thing happen, but, that was before Thanksgiving. I recovered. So, my
I'm
back.
glad to hear it. Glad you're here with us this morning. I know the inauguration is going on, and I don't want to keep anybody from that.
No,
you don't?
all I wanted to check out was the plane leaving Washington.
Oh, well, it got off the ground. I think it's gone.
Yeah, it was what it was.
If you don't mind, if we just wait, if we can wait another 6 minutes. I don't believe
Sure.
Mike's on the call too, obviously. And Mike, did we get confirmation from Mr. Appel or Mr. Manning?
Mr. Appel just called, Judge. He's working on trying to get on. He's having difficulty. I haven't heard from Manning today.
Okay. I don't think Mr. George Manning plans to attend. I don't think it's intentional. I think it's just, I set a really short time frame on this hearing. Thank you for accommodating the court.
Sure. No
But
problem.
he was unable to. So I've just finished. I've reviewed the file now 3 times. So this last time I took notes. So I think I have a really good understanding of what's happened, or I mean, there's nothing that's happened in this case, but all the different allegations and the appointments and it's unfortunate that Mr. Manning's not here this morning, but it doesn't really matter from the court's perspective. I'm just trying to, once we call the case and actually get into the status hearing, I'm really just curious to see what the hopes, intents, and plans are of the various parties in this. So
Well, I called Mr. Appel when I got wind that he was getting into the case for Mr. Hodges. So I'm not sure if he actually got served, Mr. Hodges got served, or if he just got wind of it and just went to see Mr. Appel and said, look, this is out there. Let's just take care of it. So he told me that he was going to have a telephone discussion with Mr. Manning to try to see if they could not have to litigate all these allegations. And, because he kind of is techno savvy. I mean, he knows enough about Zoom or something like that to know it's broadcast around the world. You just have to end up with the right sequence of numbers. And the court may be assigned a specific channel or whatever they do. And anybody could tune in. So he was wanting to get down to the brass tacks and see if there was some way that they could work it out without, spending an inordinate amount of time on it. Because it's not, from my understanding, I don't believe it's a very big estate. There's Mike. And so I think that was the latest that I was aware of, other than there was some discovery, maybe sometime in December, and the answers kind of, I don't know if they've come in or if they're kind of due, or, but there may have been some, this might all be hot air. I mean, he may have had a better discussion after the holidays with Mr. Manning to kind of trim down some of the issues down to really what the meat of the subject is.
okay, we'll find out in just a minute. Mr. Appel's here. Hey, Mr. Appel, how are you this morning?
Good morning, sir. How are you?
I'm doing good. Thank you for accommodating me. I told Mr. George that we were going to wait until 10:30 at least to see if Mr. Manning and you at the time were going to be available, but because of the short notice of the hearing notice, there were some potential conflicts for either of you. So I already apologized to Mr. George for putting the status hearing on a short turnaround time. And so I extend the same apology to you, and I appreciate you making the effort to appear this morning.
No apology needed, sir. I just apologize that I didn't get on quicker. I had to call Mike because I'm not real technically savvy. But I'm afraid that probably if there's anybody less technically or any more technically illiterate than I am, it's probably Chuck Manning.
Well, you're early, so you did great. We've still got, I see the time at 10:28. So, and Mr.
Yeah,
George, we didn't
there
get,
was a couple of different, one was a typed in password, and then the other below it was a numerical password. So I tried the numbers first, that said invalid. So then I scrolled back up, went to the actual word, typed it in, hit enter, and I'm here.
yeah, it's,
So,
we've all, I know I've had difficulty getting onto Zoom calls that other people, I don't tend to have too much difficulty when I set up my own Zoom call getting on it, but other people it is. Yeah, it's been fun. Well, we're almost there. We got a minute left and we'll get started. And Mr. Appel, I was just going to say, Mr. George and I, we weren't talking about the substance of the case when you came on.
And anything I've been, Mr. Manning has neglected to serve Mr. George with quite a bit of the correspondence, but I've been forwarding it to him. Anything you need to talk about, Mr. George, I have no objection to. Okay,
thank you, sir. We got about 15 seconds left. As soon as the clock hits 10:30, I'm gonna go ahead and call this. So I don't want to keep y'all on the call any longer than necessary.
Yes.
We got about 5 seconds. Get it. Okay, the time is 10:30. Court calls cause number P7926 in the estate of E.B. Hodges, deceased. This is a status hearing. It was set by the court on its own, just to try to get a better understanding. It looks like there is a shotgun approach in a rifle proceeding, and I'm trying to get an idea of what the various parties' interests are moving forward. And I know we do have we have a pending application or second amended application to probate, and we have a pending motion to strike. I don't believe either of those have been set for hearing yet. And so I just, we can do this really informally, Mr. Appel, Mr. George, however y'all want to proceed. If there's any kind of insight you can give the court on what I should be looking at. And I'll say this too, since I know that Mr. Manning is not present, but with respect to his second amended petition, I'm going to be hard pressed without case law or statutory authority to see where a probate proceeding on the estate of one individual has any ability to render any opinions, decisions, or rulings with respect to the death of another individual, or how that relates to the initial probate proceeding or the guardianship proceeding, which I tend to agree with Mr. George's position that you can't bring those together. And then the final thing that the court would note is it seems like maybe it was a convention by some practitioners over in the previous years to seek administrations of estates without any sort of judicial determination of heirship. That's not going to happen anymore. The black letter law and the Texas Estates Code is clear, and I really am not comfortable with proceeding that way again, unless an attorney in a particular proceeding can provide me with some sort of case law or statutory authority that says you can proceed that way. I'm not interested in mushing everything together and creating more strife and uncertainty for the litigants. But other than that, I'll turn it over, and if y'all could just kind of give me an update of where we are. I guess maybe Mr. Appel, if you'd like to start.
Sure, Judge. This case had been pending for, I don't know, well over a year, I think, when I got involved in it. And I filed initially just a response to keep a default hearing from taking place. But I think the guardianship is probably moot now. The mother has passed away, I think, this past summer. Also, I don't think there's probably any dispute between the two litigants that as to who the heirs are, that Mr. Manning has spelled out that the decedent in the estate administration matter is or are the two litigants, and we don't dispute that. It was two children, and both children are the biological children of both their mother and father, and so that's going to leave me with a summary judgment opportunity if I can ever get the discovery that I've propounded on Mr. Manning, if I can ever get it back. And then of course he filed that second amended answer, and I think he had even more what I considered to be hearsay evidence in there. So that's when I decided I'd file a motion to strike. If in fact the only I'm just waiting for him to finally get his client to answer the discovery that I propounded on him, that he doesn't have anything more than what some witnesses supposedly have said that the decedent said, then I will probably move the court for a summary judgment that will dispose of the case. And Mr. George and I have talked a couple of times. I don't know whether Mr. George is even still needed in the case, since it doesn't appear that the identity of the heirs is in dispute. That'll be up to you and Mr. George to decide if he will remain in the case. And I'm neutral on that. I'm just voicing what I think to be the status of the case.
No, thank you, Mr. Appel.
Yes, and I've been sitting here this morning trying to answer and lodge objections to Mr. Manning's 62 interrogatories that he served on me about 2.5 weeks ago. So we're going to answer the first 25 subject to some objections, and we'll be objecting to all the balance of them. So that's the state of my involvement in the case so far.
Thank you, Mr. Appel.
Yes.
Mr. George, do you have anything to lay over on that, or?
Your Honor, I had gone through the, basically I went back through I had the code open while I was looking at the pleadings after Mr. Appel and I first made contact about the case. I expressed to him what I thought the ultimate goal that the movement was trying to establish by the litigation, but I had asked her or told her when she was still pro se that the problems that I saw basically with the way she was trying to do it is that, one, she tried to do it by herself. Two, she had joined a number of I know that there's joinder of a lot of other causes of action, but they're separate and apart from usually things in the estate code. So we had this guardianship that was going. The spouse of the decedent, in the style of this case, was in a nursing home. We had, by the time I actually got a firm idea of where she was, we had rolled into this pandemic. And the nursing homes, even though in what I call maybe a rural county, to me, a rural county is if you're maybe 25, 30,000 people for the whole, there's more cattle in those counties than there are people sometimes. but they had shut down nursing homes statewide. Pretty much had really had to clamp down because the COVID was so bad in a, you know, and as you know, also in jails and in the TC system, also hospitals in general. So they were really trying to keep any people from unnecessarily coming into and out of the nursing home. So I talked to staff and they said, you know, they indicated to me that no, I couldn't come to see her. And I said, okay, is there any way I could call your cell phone and get you on FaceTime and have you hold the camera up where I could see her in her bed? And if she's responsive, fine. If she's not responsive, I just need to know. And then the restrictions got tighter and tighter. And unfortunately, I'm not sure, I have not seen a death certificate, but she was in, she being the decedent's spouse, had been in pretty ill health. I think her needs were being addressed. She was in a nursing facility. I don't know what kind of you know, if I couldn't get in to see her, I don't think any family members were being let in either. You know, I have my mother-in-law was in a nursing facility here in Corpus, recovering from some pretty. I thought certainly she was going to go during the COVID, but she's tough. I mean, she's a tough Hispanic woman, you know. I mean, you know, that raised 4 kids by herself. So she hung in there. She's still kicking it, hanging in there. You know, it's taken a toll on her, but I don't know. I've never had a vantage point to start from as far as whether or not Mr. E.B. Hodges, the decedent in this case, you know, what sort of situation he was left with. You know, I wasn't able to get medical records or just a quick, maybe a Xerox peek, you know, just take me a little snapshot. Just let me kind of look, you know. But I kind of get the idea that the surviving spouse that has since passed away, I believe in July of last year, was pretty much non-responsive. There was a question that she had actually resided in that nursing facility for a number of years. So I always thought the venue was probably wrong. And that, you know, and nobody else, I think, lives in B County except maybe Mr. Hodges. He may be over in Live Oak. The son, I think he goes by Edward Benton Hodges. And Miss Bench lives in Travis County. Well, it says Mr. Hodges lives in Live Oak County, according to his amended pleading. And the surviving spouse had resided, I think, in Goliad. And so there was really no nexus to B County. And I mean, historically they may have been, but not at the time of the filing, because she had been in the nursing home for years at that point. And there's, I don't think there's any dispute as to who the heirs would have been, or the heirs at law in an heirship finding would be Cheryl A. Bench, who's the petitioner, applicant, or movement, and Mr. Edward Benton Hodges, her older brother. And these were the only children. I don't believe there were any other children born that maybe had children that survived their parents. That's not alleged in the application. So, you know, I'm pretty well confirmed in my feeling that Cheryl Bench and Edward Benton Hodges are the only would be the only heirs of E.B. Hodges and or their mother who passed last July. And then there was some confusion about whether there was even an interest in the property. That's I'm sure is going to be the subject matter of the complaint. You know, once you kind of get the gravy and all the other stuff off the top, you know really what the meat of the subject is.
You're operating this.
There's some allegation. I mean, it's just not even a factual allegation. It's just, this is what I think.
Yeah.
That there is supposedly a will floating around, or it was floating around, that supposedly belonged to the decedent E.B. Hodges, which,
Hearing so bad.
you know, we're pretty small, you know, kind of community. There's not too many people that would have known somebody, perhaps, you know, it's just been my experience. They tend to go locally instead of traveling, you know, unless it's a really big estate. So I don't know if it's, if that is a possibility. I don't think it's on file. I mean, you know, like with the clerk's office for protection or safekeeping. And then, you know, we got past the actual time to really, I mean, I don't know if just because they filed an application or maybe it got filed late. I don't know if you can get past that 4-year post-mortem, you know, to get an administration going, because I don't know that there was really a necessity at that point. I really don't know. And then I think there was supposed to be like an affidavit that, you know, some of these things could be corrected, but there were like an affidavit of the applicant that everything in the pleading was true and correct. That the allegations would be true and no material facts had been omitted, so that I wouldn't go down a, you know, or the court goes down a, you know, bunny trail or something. And, you know, we needed to, the unknown heirs, and it was very difficult. You know, Mr. Manning kind of took over a pretty heavy situation. I don't know how, you know, I mean, I don't want to get into his attorney-client privilege, but it was difficult at best to get information from his client, because and her daughter was trying to assist her because she had, you know, some issues with her eyesight, which was getting poorer and poorer. And then I believe she ultimately had some cataract surgery. And I think she's hopefully on the other side of that, where she starts recovering eyesight. But she, you know, would have to look at small print with a big magnifying glass and hold it up to kind of look at everything. So that was kind of a little bit of an issue. And then, you know, as far as like arguing over the real property, I think that all the persons, you'd have to show some kind of interest in the ultimate outcome of the determination, you know, of whatever the issue is before the court, to show that, like, you know, we were co-tenants or we were partners or somehow, because the rest of the world's not going to know this microcosm of disagreement between the brother and the sister, especially as more time goes on. It's been 7 years, I think, since the senior Mr. Hodges passed away. And now with the subsequent passing of the spouse, it makes it even more difficult because we don't have anybody that can corroborate any of this. You know, any disinterested witness. And to me, it doesn't pass some of the exceptions in the probate code, like a end of life, I think that just, those things, like a deathbed type, oral recitation, I don't think that applies to real property, but I think it's directed more towards, personality has to be reduced to writing and substantially reduced to writing and agreed by all the people that heard it said. And I think it has to be simultaneously done. It can't be that, with this new development of Zoom, that might change. We may have an amended new rule or something, but or an amended rule that kind of adds some additional exceptions under the circumstances where I'm not actually physically there, but we're all in different locations and we're actually seeing the same thing happen simultaneously. And if we have a good connection, then the sound comes and the lips move all at the same time, instead of like an older movie where the lips are going and then the sound comes out. So I think where they're at is there's some discovery that has been propounded. I don't know, my original appointment was for the airship, and then that got sort of stretched out to then kind of include the surviving spouse as a person that was somewhat infirm, because we still had to do an airship determination on her husband, but at the time there wasn't anything necessarily in her name. So I don't know if that was, estate planning through somebody else, or when that, all these things actually happened. But there were issues. I don't know how many of them are actually maintainable versus being moot because of the subsequent passage of time and or the passing of the surviving spouse. And I don't think an estate's been open for her. I don't know that she necessarily had anything remaining that was in her name. So I would defer back to the court, and I see that Mr. Manning's with us. He may be able to fill you in with some more detailed information.
Great. Thank you, Mr. George. Mr. Manning,
Yes,
thank
sir.
you for being, I know this was short notice, and I know everybody had to shuffle their schedules around to accommodate the court. I want to extend my appreciation to you for being here this morning. It's just a status hearing. There's no decisions, no rulings, no evidence. We're just talking. I've gone through, I told Mr. Appel and Mr. George, I've reviewed the file now 3 times. This 3rd time I've made notes. I think I have a good timeline to look at. And I know there's your current life pleading, your second amended petition has multiple requests. And I know Mr. George was appointed. And I know we have your pending second amended application, and we have Mr. Appel's motion to strike. Neither of those have been set. So the court's I'm just giving you, that's the rundown of where we are. And I just thought it would be useful for the court if I could have you guys give me an idea of what's next and what you're thinking, and if there's something that the court can provide to help streamline that process to get these matters resolved one way or the other. So I'd give you an opportunity. Mr. Appel had kind of gave me his synopsis, and you came in when Mr. George was giving me his synopsis, and I'd give you the floor now. Take as much time or as little as you'd like.
Okay, I appreciate it, Your Honor. Can you hear me okay?
Yes, sir.
I'm sorry. I was in another hearing, a Zoom hearing, and of course there was problems with the my computer. I had to come to the courthouse and use the Zoom program here. And I'm up in another room using another Zoom program. But anyway, the first thing that comes to my mind is that I don't see where Michael George has a role to play in this case. he was present when we went to court in 2017. And by the way, I don't have my file here, so I can't really look
That's
at it. But I think it was back in not 2007. I think it was 2019, around December of 2019. He came to court, and we at that point were still looking for Mr. Appel's client, which is Edward Benton Hodges. And so I thought Michael George was probably going to be the ad litem for Edward Benton Hodges. But Judge Moreno told us to notify Mr. Hodges and see if we could get him to respond and, get involved in the case. So we did. And then eventually, after about 6 months, I think, he ended up coming to my office, and I told him, look, you need to get an attorney, and you need to, pursue whatever you want to pursue in this case, trying to be fair to him as well as my own client, of course, although he's not my client. And so he ended up going to Mr. Appel, and Mr. Appel is now representing him. And I don't know of any other unknown errors that would be involved in this case. If there is somebody else, I guess that would be appropriate for Mr. George to represent them. But I don't know of any other parties or any other people that would be unknown or known errors, because the father, E.B. Hodges, of my client was also the father of Edward Benton Hodges, and they were the only two children that he had. So I think that there's a question whether Mr. George has a role to play. I'm certainly not trying to dismiss him or criticize him, but I just don't understand what his role would be. Now, as far as what the status of the case is, Mr. Appel has filed a motion opposing the amended application that I filed, and I can understand his objections. I don't really agree with them, and I think that there would be it would be a good idea for the judge to make a ruling about that, since it is filed. Mr. Appel's motion has been filed to strike that pleading, and if so, then I'd have to revise the pleading. Basically, what he's complaining about is hearsay being referred to in the application. And I don't understand that there's any law, and I didn't see any citations in his motion referring to any law that says you can't put hearsay into that kind of pleading. I really put it in so that he would know, Mr. Appel would know, and also Mr. Edward Benton Hodges, his client, that my client is going to be making those comments when she comes to testify. Now, the other thing is that we have discovery. Well, there are a couple of other things, but one of them is that we have discovery underway. And Mr. Appel has been very courteous in allowing us to have extra time, because my client has had cataract operations, and we thought she was going to be, this is about a month ago, I guess she had the first one. We thought she was going to be back on her feet and functioning normally, but she's not. The cataracts have required additional operations. Apparently, she is not able to read documents as a person normally would. And of course, she's also in her 70s, and I think that there's some degree of loss of mental acuity due to the passage of, due to her being old. So I'm having some problems with her, and that's why I'm trying to get Michelle Lawrence, her daughter, who was present at that hearing in 2019 before Judge Moreno. I'm trying to get Michelle to function as her assistant. And I did put in the application that I filed, the amended application, that we were going to try to have her to assist Cheryl. Cheryl cannot drive, and right now I don't think she can read, and she really doesn't seem to understand what's going on in the case as well as she should. And she does not have the electronics. For example, I don't think she could participate in a Zoom hearing. And I think she has trouble with email and other things like that. So there's some difficulties that we're having going forward with her. But there's one other thing I was going to mention, and I'm sure what it was, but I think those are the main concerns that I have right now. We do have some deadlines on discovery that I'm trying to meet. Mr. Appel has also, I've filed interrogatories with him, and I'm sure he's going to be responding to that. And I think that I need to do some more research with regard to some of the issues. The main issue in this case is what was the status of this real estate that was in Mr. Hodges' estate when he passed away. Was it community property or was it separate property? And of course, when he passed away, his wife, Norma Grace Hodges, was still alive. And I thought Mr. George was going to represent her, but apparently, and I think he went up and saw her, but I don't know if he ever took on representing her. However, she died last July. And so whatever was in her estate devolved in a manner that we don't know to her surviving relatives. And that would be Edward Benton Hodges and my client, Cheryl A. Bench. And I think that there was a will that Mr. Edward Benton Hodges showed me when he came to my office that was signed by Norma Grace Hodges. And I don't know if that's been probated or filed or if it still exists or whatever. And I also have heard fairly recently that a lot of people believe that Edward Benton Hodges, the father of the deceased, in fact, he goes by E.B. Hodges. He doesn't use Edward Benton, or didn't use those words, so it's E.B. Hodges. A lot of people have told me that he had a will or made several wills, and that those wills involved the distribution of his estate upon his death to his children. And there was questions as to whether the last will that he did still exists. Apparently, Cheryl Bench has told me that it was, or somebody, I think it was somebody else told me that the will was in a safe on the property, which apparently Edward Benton Hodges occupies at this point. I'm not really sure about that. But anyway, the will was supposed to be there. And if it can be found, I think that would be something that would be important. And I also think that it might be important if the will of Norma Grace Hodges is filed for probate, because I don't know what she did with the property that was in her estate. Mr. Appel has said she didn't have any property when she died. I don't really think that's the case. If this property was community property, the real estate, 58.27 acres, was community property when she died, then I think that that would have devolved to the two children, and that, it depends on whether there's a will or not as to whether that passage of that property would be in accordance with the estates code for intestate persons. So we have some issues here. I think this case is moving slowly, mainly because Cheryl Bench's disabilities, but also because it's kind of complicated, because we're going to have to determine if the property that was in E. Hodges' estate was separate or community. And I think that's the main issue that is yet unresolved. And by the way, I have not had a chance yet. I'm trying to get into determining what happened with regard to E.B. Hodges' father or grandfather. I'm not sure who it was. But anyway, supposedly he left him, when he died, that other Mr. Hodges died, he left E.B. Hodges a lot of money. And what I've heard is that E.B. Hodges used that money to buy this property in B County, the 58.27 acres. Before that, they lived in Corpus. There were some disputes and things that happened in Corpus that were somewhat relevant to what this case is, how this case is going to come out. Because apparently, from what I've heard anyway, and this again is hearsay, as Mr. Appel is right to identify it as that. What I've heard is that there was a dispute between E.B. Hodges and Edward Minton Hodges. And E.B. Hodges did not want to have his property passed to Edward Minton Hodges when he passed. Okay, so those are some of the issues that are still out there. And I think that doing some research into the death of this older Hodges relative would be important. I haven't done that yet. Mr. Appel asked for any documentation that I have, and I may have some, but I don't have it right now. May have it in the future. So what I'm suggesting, Your Honor, is that we let this case go forward and finish the discovery, and then Mr. Appel's motion to strike can be heard, and I think that we should, assuming that you grant it, I'll have to figure out what to do about the application, and then we'll have to get a final hearing. And it seems to me it's going to be some time before we can do all that.
Yeah. Mr. Manning, do you recall off the top of your head that statutory reference I mentioned to you in another probate proceeding with respect to the requirement of obtaining a judicial declaration of heirship as a prerequisite to an administration of an intestate estate? I don't remember it. I was trying to look for it just a second ago, and I don't know if it relates only to independent administrations or if it relates to all intestate administrations. And that would be insightful in this proceeding because I presume your second amended petition is requesting a dependent administration because it doesn't specifically request an independent administration. There's no affidavits or consents on file with respect to the other purported heirs. But from the court's perspective, as an initial matter, that would be good for you as the applicant to make that determination. Do you need to obtain a judicial declaration of heirship? I understand, and I saw from the court's file that there was a December 2019. I think there was a hearing November of 2019, and then there was a hearing December of 2019. And the notes in the court's file is just on the front of the jacket, and it just says final hearing twice. And on the computer record, it just says final hearing twice. So you guys know there's no record I can go back to. There's no review of what was said or the testimony was presented, and that was all done in front of Judge Moreno. So I'm operating a little bit of a loss. And my understanding from reading the file is Mr. George was appointed after Mark Eggert withdrew or requested to be excused. And Mr. George was appointed to represent the unknown heirs when I presume the court was being generous. This was before, I think this may have been before around the same time, Mr. Manning, that you got involved in the case, and well before you did, Mr. Appel. And so I presume the court was being generous with its interpretation of the then pro se applicant's pleadings that she had requested a judicial determination of heirship. I know that's not in your current pleading, but I did express to Mr. George and Mr. Appel that this court is no longer going to consider administration of intestate estates unless there's a judicial determination of heirship. And I get it, but I get the arguments contrary to that requirement. But my understanding, I just can't find the statute, is that it's a statutory prerequisite, and there's no real way around it. So it could be that Mr. George has already, and I believe he's already exercised that duty, and at a final hearing or in writing in the final report, we can get that wrapped up and moved on. I tend to agree with all of y'all that Mrs. Hodges has passed away. There's no guardianship proceeding anymore. There's no necessity for that appointment. I'm concerned how Mr. George is going to be paid. He needs to be compensated for his services, and I think everybody acknowledges that this is something of a messy, complicated matter, and at least it was in the initial at its inception. And I think the entry into this proceeding by the three of y'all will definitely help streamline it and make sure that all the issues that you guys want to bring or are concerned about addressing, that you're addressing them in the correct court, in the correct proceeding, and at the right time. But I'd ask you that you look at that, Mr. Manning, and make sure that all your ducks are in a row. The court's not going to be in the habit of we'll set hearings when you guys are ready to set hearings, but I don't really want to be the I don't want to be the advocate for any party, so I really don't want to tell y'all to go look at the estates code and figure out exactly what you need to do, and then present it correctly to the court when you're ready for the hearing. But I'm happy to try to answer any questions that you guys have. If you have any questions in the future, of course, please put them in writing and communicate them to the court, and copy all counsel on them. I'm happy to give you guys as much time as you need. It doesn't matter to the court. I do know the case is old. It's been on the book since 2017. It looks like it was initially filed to preserve the 4-year statutory right. And since that time, which is 3 years ago, there still has been no presentation of a will in court. There's been no motion requesting investigation or turnover of a will or purported will. There's been no indication other than our discussion, our informal discussion today, and some statements in pleadings that some other wills out there might exist. Far be it from me to tell anybody how to do their job, but every day that passes, I'm guessing it's going to be harder to find a will, if a will does exist, if it ever existed, regardless of if somebody's trying to hide it or not. Time passes. So I really appreciate it. I like I said, I know you guys are, I know now that you guys are engaging in some active discovery. I'm going to keep Mr. George on. I'm not discharging Mr. George at this time. But I want to give you, Mr. Manning, an opportunity to get your pleadings in the order that you believe are sufficient, and then we can move forward with setting the various any motions for hearing. If there's anything that needs to be brought up or taken up prior to a final hearing, I'm happy to do it. I'm not setting hearings the third Thursday of every month. I'm setting hearings as I can whenever the attorneys are available. So you guys figure out when you want to present anything to the court, and just let Mr. Loya know, and we'll immediately try to accommodate you. And if all the attorneys on the case agree, I can have a hearing tomorrow if you guys want to. It's really not a big deal. That's the only silver lining with Zoom, is it makes this a lot easier. Now actually, getting anything done or accomplished, it's a little bit harder because we're not in person. But I really appreciate the insight. I don't really have anything else that I know of. Does Mr. Appel or Mr. George, would y'all like to say anything further at this time?
Not me, Your Honor.
Okay, thank you, Mr. Appel. Mr. George?
I have a sort of some notes from, I think I used these the last, actually, I think what I did is I have a tendency to kind of pack rat stuff. So, because I find it's easier to pull out a code, excuse me, a code that is paperback, and I just saved it. And so I had probate codes going back to the 90s. And so what I had done was go back and look at the probate code as it existed in 2013. And I just made a note here that the section of the code that I saw back then was 202.006. And that had to deal with requests for determination of necessity for administration. That might just, I've already kind of looked it up. I didn't really spend a lot of time on it, but that might answer our question, or the question that, is there a necessity for an administration?
Okay. That is, and I'm looking at the disposition table. It looks like section 202 of the TPC became section 305-204 of the Estates Code. And that's that section is a lien on real property owned by personal sureties. That doesn't sound right.
Let me see here. Okay, it's the section that's right past it's 202.006, and it's right past the statute that has all the requirements for an application for proceeding to declare heirship, which is 202.005 of the Estates Code. And it just deals with the request to have the court determine whether or not, this is within the 4-year statute, and the applicant have a request to the court to determine whether there's a need for an administration.
Okay. Yeah, I mean, and going through all of this, the court's not trying to give any indication to the parties that a necessity does in fact exist or does not exist at all. I'm just trying to go back to what steps, I don't want you to get everything ready and then the court surprise you and say, oh, King's X, you have to do this first. So, but I don't have to look at the statutes in front of you guys, and I don't need to keep y'all on the Zoom call anymore. If there's nothing further, I'll look at it. I'll shoot y'all an email, or have Mr. Loya. I'll shoot you an email when I find the statute. I know I've got it somewhere because I just looked at it. It was 2 weeks ago, Mr. Manning. I think it hadn't been that long, so I know it's somewhere in the book. But I really appreciate your time. If nobody has anything further, then we can wrap up. Mr. Manning, do you have anything further?
Yeah, I did want to tell you that our application states that there is a necessity for administration, and it cites the statute.
Yes, sir.
It's in the Estates Code.
Yes, sir.
And you mentioned some other advice that you'd given me earlier. That had to do with a probate case where the copy of the will was available and not the will itself, and we had to get service of process on the heirs. So
My apologies. It must be another counselor. It's got to be. I'm really sorry. I'll find it and I'll let you guys know. Yeah.
Right. But in any event, I think we touched on the main concerns and issues in this. And as I say, I'm having some problems with my client. Mr. Eggert withdrew from the case because Cheryl Bench couldn't understand that he didn't represent her. So that gives you an idea of what some of the problems are with the case. And I do think that it was filed just before the expiration of the 4-year period. And there's a lot of what happened was that I was told that by Judge Moreno that somebody should take over the case because she didn't know what to do with it. I think it's probably sort of the same thinking that you have right now. It's confusing and complex. But I do think we're headed in the right direction, and I think that Mr. Rappel is being cooperative. He's definitely going all out for his client, which I respect that, and he's being cooperative in the discovery efforts that we're making, and so I think we can get there before too long, hopefully.
Okay.
And I appreciate your concern about this.
Yes, sir. I'll give it 4 to 6 months, and if I haven't heard anything from y'all, I'll set it for another status hearing just to kind of make sure we're moving forward.
Right, and if you want to have a hearing on Mr. Appel's motion, that's fine. We will have to figure out whether it's going to be by Zoom or whatever.
Yeah, I'll set motions for hearing in this court upon the request of the parties filing the motions. You can file as many motions as you want and just let them, we can consolidate them for one big hearing. That's no big deal. I'm not going to, unilaterally set hearings just because somebody's filed a motion. So rest assured.
And I do want to say again that I think there's some issues here. Usually it doesn't come up in this manner, at least not in my experience, but there's some issues here, whether there was a will of E.B. Hodges, because everybody's telling me that he had a will. He definitely wanted to have and he was an intelligent person. He's not the kind of person that would not even think of doing a will. And then again, Norma Grace Hodges, I feel like her will would be relevant to this case because the theory that is being used by Edward Minton Hodges is that when she survived E.B. Hodges, she had the authority to deed all of her property to him, to Edward Minton Hodges, the son. And that was based on his understanding that the property was community property, which I don't agree with that. We don't agree with it, but we may not be able to prove it. That's the thing. We're going to try to prove it.
Right. And I understand when it comes to real property, maybe y'all have an opinion on this that you can give me some guidance on, because I looked at that, the inception of title and what the presumption is. And I know that the family code makes a presumption that in the absence of any indication otherwise, ownership is presumed to be community. And then in order to rebut that presumption, the level of evidence necessary is a clear and convincing standard. It's a very high standard. And that, that could potentially be an issue that could be determined in this proceeding. It's kind of interesting. It would look like, depending on how things go in this proceeding, some of the other issues that you have might be more of a dispute as to title to real property, deck action, stuff like that, which is probably not proper in probate court. I know I have expansive authority when I'm wearing a probate hat, but I'm not sure that it can stretch that far. But that's way down the road. So I think there's some pretty substantial steps that have to be completed before you guys even get to that point. So.
Well, again, I thank you for your attention to this.
Yes, sir. Thank you, Mr. Min. Mr. Rappel?
No, Judge, we thank you for your time today. I've said all I need to say.
I appreciate that, Mr. Rappel. Thank you, sir. Mr. George?
Have nothing else to add, Your Honor.
Hey, thank you guys so much. I really appreciate it. And
Sure.
y'all have a wonderful day.
That's the plan.
Okay.
Thanks, Judge.
Okay.
Later. Goodbye.
Bye-bye.